The objective behind this video is to discuss the 100 most probable themes which may be very relevant for the preliminary examination 2023 for the subject Indian polity. So the discussion would cover most of the important current events, the contemporary issues, as well as some of the static topics, which can give you a good hold for revising the subject Indian polity before your preliminary examination. So myself, Babu Gunasekaran, I have secured All India rank 337 in the Civil Service Examination 2016. And I also secured All India rank 37 in the Central Armed Police Forces Examination in the year 2009. Let us go to the question and we'll try to solve the question and try to revise the things for the examination. Come to the first question. Consider the following statements. 1. Conviction on defamation is a ground for disqualification of the members of parliament. Statement 2. Defamation is a criminal offence under the Constitution of India. Statement 3. Any member of parliament convicted on the grounds of defamation will not be able to contest election for another 6 years after the completion of his term. Which of the statements given above is or incorrect? So before we solve this particular question, let us try to understand the context in which this particular question is asked. Recently, Mr. Rahul Gandhi, who was a member of parliament, was convicted of criminal defamation and he was punished for 2 years, and subsequently he was also disqualified to be a member of parliament. So in this context, this question becomes very, very important. So before we solve this particular question, let us try to understand what are the other statutory provisions or the constitutional provisions which may be relevant to this particular question. First, you should be aware of section 499 and section 500 of the IPC. You should also be aware of article 19 of the Constitution, then article 102 and article 191, and most importantly the Representation of People Act 1951. Now section 499 of IPC defines as to what is a criminal defamation. So defamation can definitely be a criminal offence in our country. And what section 499 of IPC says? Any individual whose communication, be it in oral form or in written form, which is trying to bring disrepute or trying to damage the reputation of another individual, then the court can find him guilty of criminal defamation. And what section 500 of IPC says? Section 500 of IPC says the court can give a maximum punishment of 2 years. Someone who is found guilty of criminal defamation. And how article 19 is relevant? Article 19, we know that it provides for the right to freedom of speech and expression to all the citizens. But however, this right to freedom of speech and expression is not an absolute right. It can be reasonably restricted because the Constituent Assembly members wanted this right should not be absolute. Something absolute is dangerous. They wanted to balance between the individual liberty on the one hand and also the societal welfare on the other hand. And hence, on the one hand, they have given the rights, but with certain reasonable restriction. And one of the ground on which it can be reasonably restricted, the right to freedom of speech and expression, is on the grounds of defamation. Apart from defamation, there are also 7 other grounds on which they can be restricted. One is on the grounds of the sovereignty and integrity of India. 2, security of the state. 3, something which is affecting the friendly relation with a foreign country. 4, on the grounds of the public order. 5, something that is related to incitement of offence. 6, contempt of the court, and so on. So there are certain grounds on which they can be restricted. How Article 102 and Article 191 is relevant to this question? Both Article 102 and Article 191, respectively in case of the members of parliament as well as the state legislature, provide certain grounds on which they can be disqualified. Say for example, Article 102 says, Article 102 of the Constitution says somebody who has given up the citizenship, they can be disqualified. Somebody who is found as an undischarged insolvent, they can be disqualified. So the similar grounds are also for the members of the state legislature. But what is interesting about Article 102 and Article 191 is that they have not only given certain criteria under the Constitution, but they also empowered the parliament to make a law, and by that law, the members of the parliament and the members of the state legislature can further be disqualified. So one such law that is made is the Representation of People Act 1951. So if you see under this Representation of People Act 1951, especially under Section 8 of the Representation of People Act 1951, it provides for the disqualification of the members of the parliament as well as the state legislature if somebody is convicted of any criminal offence, provided that their conviction is 2 years or more. If their conviction is 2 years or more, then they can be disqualified. This is what the Constitution says. This is what the Representation of People Act says. But it has to be noted that the conviction has to be 2 years or more. The same Section 8 also says, but there are few convictions under certain categories of laws, which is mentioned in the Representation of People Act itself. For example, conviction under the Customs Act, conviction under the Protection of Civil Rights Act. Under those laws, if the conviction happens, it doesn't really matter as to what is the term of conviction. They immediately get disqualified. But otherwise, if the conviction on any of the other laws, then the minimum conviction has to be of 2 years, then only they actually get disqualified. So with this information, let us try to solve this question. First, conviction on defamation is a ground for disqualification of the members of the parliament. It is very important that you have to understand, conviction on defamation per se is not a ground for disqualification. So conviction on defamation, and if the punishment minimum that is given is 2 years, then they can be disqualified. Suppose if somebody is convicted on defamation, but the punishment given is 6 months, because the maximum punishment is 2 years, but the minimum punishment can be less. So if the maximum punishment is 2 years and if that is awarded, that is a ground for disqualification. So conviction on defamation per se automatically is not a ground for disqualification. So what has happened in case of Mr. Rahul Gandhi? Mr. Rahul Gandhi is convicted of criminal defamation and the punishment is also 2 years, which was given by the court. So he is already disqualified, but otherwise conviction on defamation will not automatically amount to disqualification. 2. Defamation is a criminal offence under the Constitution of India. It is partially true. Yes, defamation is a criminal offence, but not under the Constitution of India, but under the statutory provision, that is the Indian Penal Code. So this particular statement is also wrong. Third statement, any member of parliament convicted on the grounds of defection will not be able to contest election for another 6 years after the completion of his term. So any member of parliament convicted on the grounds of defection, first of all, will be disqualified. When they will be disqualified? Only if the punishment is greater than or equal to 2 years. So here it is only talking of conviction on the grounds of defection, but it is not saying the quantum of punishment. And hence we cannot make an assumption that conviction on the grounds of defection will automatically lead to their disqualification unless and until the quantum is minimum 2 years. So this particular statement is also wrong. So which of the statements given above are incorrect? So the right answer would be option D. So now do you understand how you'll have to prepare? So just to add one more information, now there are a lot of articles with regard to disqualification of Mr. Rahul Gandhi. Will he be able to contest the election again? But he is already disqualified because the law says once you are convicted for minimum 2 years and then you are automatically disqualified immediately. But the law also says if he can go for an appeal in a higher court within the reasonable time frame, and if the higher court stays the conviction, this is very important, not staying the imprisonment, stays the conviction of Mr. Rahul Gandhi, then he may be able to contest election in the future. Okay, so this is what you should know about this particular question. So we'll also move to another question which is also very relevant for the examination, which is also very contemporary in nature. So please come to the question number 2. So let me just read the question and then go to the discussion. Consider the following statements with regard to the anti-defection law. Many times in news, I'll also explain as to the context why this is relevant for the examination. Before that, let me just read out the statements. Statement 1. The President of India and the governors of the state or the disqualifying authority in case of defection under the Constitution. Statement 2. Once disqualified under the law, the legislator cannot contest election again from that constituency where he or she got elected. Statement 3. The 10th schedule of the Constitution deals with the anti-defection law. Choose the correct option from the quotes given below. So let us try to understand what are the things that you'll have to revise with regard to this particular question and what is the context. The context is most of you might be knowing that recently that the Shiv Sena party, there was a defection. Mr. Eknath Shinde faction has joined the BJP party, and subsequently now the matter is pending in the Supreme Court, and the Supreme Court is also looking into the various aspects of the anti-defection law. So in this context, this question becomes very, very important. So what are the things that may be relevant here? Again, Article 102 and Article 191, 10th schedule of the Constitution, and in general your idea about the defection law. Article 75 of the Constitution could also be relevant for this particular question. So what about Article 102 and Article 191? We have already seen that it provides certain grounds for disqualification. In fact, apart from the grounds that is mentioned in Article 102 and Article 191, by the 52nd, which means originally the defection was never a ground for disqualification. But however, by the 52nd Constitutional Amendment Act, in the year 1985, by the 52nd Constitutional Amendment Act, defection was also inserted as a ground for disqualification. There are reasons for that. The original Constituent Assembly never thought that defection will happen, but then subsequently there are a lot of issues of defection and they have to amend the Constitution, and they brought in this defection as a ground for disqualification. And they also inserted a new schedule into the Constitution, that is the 10th schedule into the Constitution. And this 10th schedule of the Constitution provides the grounds for disqualification. What are the various grounds on which both the members of the Parliament and the members of the state legislature can be disqualified? So the law says, the 10th schedule says that somebody who voluntarily gives up the party membership, who votes contrary to the party direction, an independent member joining a party, a nominated member joining after 6 months any of the party. So these are the grounds on which they can be disqualified. So you can revise the grounds on which they can be disqualified. So 52nd Constitutional Amendment Act inserted the 10th schedule. That is something that you should remember. And most importantly, you will have to understand, while the members of the Parliament under Article 102 and Article 191 if they are to be disqualified, the disqualifying authority is the president for the members of the parliament and the governors for the members of the state legislature, the exception being disqualification on the grounds of defection. The 10th schedule says that if any member of parliament or a member of state legislature is to be disqualified on the grounds of defection, then who has the power to disqualify them? It is the presiding officer and not the president. So in case of Lok Sabha, it will be the speaker, and in case of Rajya Sabha, it will be the chairman of Rajya Sabha. They are the disqualifying authority. They have the power to disqualify. And what else we can add? So once they are disqualified to be a member of parliament or a member of state legislature, Article 75 of the Constitution also says that they are not eligible to be appointed as a minister for the remainder of the term for that particular house. It is very, very important. It doesn't mean that they cannot contest election. If any member of parliament is disqualified, then automatically there has to be a by-election because there will be a vacancy in the house. So the members who are disqualified, can they contest in the by-election? Yes, of course they can contest in the by-election. And if they win the election, they can also be appointed as a minister. But without winning the elections, after being disqualified on the grounds of defection, they cannot be appointed as a minister. Very, very important. So this is what Article 75 of the Constitution says. So why this is very important? Because the law also says, the Constitution also says, even if someone is not a member of parliament, still they can be appointed as a minister for a period of 6 months. But that will not be applicable for someone who is disqualified on the grounds of defection. So someone who is disqualified on the grounds of defection, can they become a minister? Yes, they can. But they have to first get re-elected to the house by contesting in the by-election. So this is the understanding you should have. Now with all these information, let us try to solve this question. The President of India and the governors of the state, or the disqualifying authority in case of defection under the Constitution. They are not the disqualifying authority. So in case of defection, we have clearly seen who is the disqualifying authority. The disqualifying authority is the presiding officers. 2. Once disqualified under the law, the legislature cannot contest election from that constituency where he or she got elected. They can very much contest in the by-election. Okay, so this statement is also wrong because it is saying that they cannot contest the election. Statement 3, the 10th schedule of the Constitution deals with the anti-defection law. This is true. It is the 10th schedule that deals with the anti-defection law. So which of the, choose the correct options from the quotes given below. So the right option would be, that is 3 only, that is option B. So in addition to that, probably you can also add one more thing, that is the 91st Constitutional Amendment Act, which has made few changes in the defection law, which has changed the exception under the defection law from 1/3 split to 2/3 merge. So please understand, whenever you read something, you will not only look into the specific contemporary development, but you'll have to cover all the things that is relevant to that particular topic. In this way, if you prepare, your chances of attempting and getting most of the questions right is much higher. Okay. Okay, let's move to the next question. Look into the question. The Speaker of Lok Sabha can be removed by a resolution passed by which majority in the House? Very simple question. Simple majority, special majority, absolute majority, effective majority. What is the context? Why this topic becomes very important? Otherwise also majority is a very important topic. Recently there was a news where there's a resolution that was introduced in the Legislative Assembly of Maharashtra. For the removal of their deputy speaker. So it becomes very important for us to understand as to how these people can be removed. So I'm just going back to the question again. The Speaker of Lok Sabha can be removed by a resolution passed by which majority? The answer is very simple, that not only the Speaker, it is also the Deputy Speaker, the Chairman, the Deputy Chairman of Rajya Sabha, and also in case of the Legislative Councils, all these members can be removed only by an effective majority. So it is also very important for us to understand as to what is the distinction between these majorities. First, what is simple majority? Let me just quickly go through it. Simple majority is nothing but the majority of members present and voting. You'll have to only see as to whether there is a majority of the members who are present and voting, nothing more than that. Absolute majority, we are not concerned about the members present and voting. We are concerned about the total membership of the House. Total membership of the House. So for example, if the total membership of Lok Sabha is 543, we need to have a majority of this. But in present and voting, let us assume that on a given day, there are 500 members who are present, but out of 500 members who are present, let us only assume 400 members are voting. So we need just a majority of this. So because this is present and voting, we are not concerned about how many are present, we are concerned about how many are present and voting. Probably the majority could be 201. This is simple majority. Probably here you need 272 as the majority. And then what is the effective majority? The effective majority is the majority of the effective membership. The majority of the effective membership. How do you calculate this effective membership? Effective membership is equal to total membership minus vacancies. So we are not concerned about the members present and voting, we are concerned about the effective membership. Suppose if the total membership is 543 in Lok Sabha and there are, let us assume, 13 vacancies. So the effective membership is 530 and the majority of the effective membership would be equal to the effective majority, which in this case would be 266. So that is how you calculate the majority. Now remember, under one condition, the absolute majority and the effective majority would be the same when the vacancies are 0. Under the constitution, you'll have to understand there are only 4 types of majorities. One is simple, special, absolute, effective. So apart from these 3 types of majority, that is simple, absolute and effective, the other types of majorities are called as special majority. Although there is no one special majority, there are different forms of special majority for a different purpose. Say for example, for amending the constitution, there is a special majority. For removing the President of India, there is a different type of special majority. So special majority can be different for different purpose. But you just try to have a basic understanding of what these majorities and where these majorities are used, which may be very relevant for your examination. And just one more note before I proceed to the next question. Now, in case if the majority is not mentioned for a specific purpose under the constitution, then the majority that has to be taken into account is simple majority. Remember this. Unless until a specific majority is mentioned, which majority has to be taken into account? It is the simple majority. This is also a very important topic for your preliminary examination. Let's move to the next question. Look into the next question. Consider the following statements with regard to the presidential election in our country. So why this particular question is very relevant and very important? In June 2022, the presidential election was over. Mrs. Draupadi Murmu was elected as the President of India. The president election happens every 5 years in our country unless and until there is any vacancy to the office of the president. So this also becomes relevant for your examination. A number of things you'll have to revise before you go to the examination. It can be with regard to the qualifications for someone to contest the election. It can be the conditions of the president's office. The questions can be from the electoral quota that is required for someone to get elected as a president. The questions can be on the type of elections, that is the proportional representation. The question can be from the electoral college of the president. The question can be from the census that is used for the presidential election. So anything can be asked. So it's very, very important. The question can also be from the value of votes of MP and MLA. Of course, not their value specifically, but the formulas and the inferences that you have to derive out of these things can be asked in the examination. So once you prepare all those things, any question that can come from this particular area, I'm very sure that you will be in a position to answer that particular question. So come, let us try to solve the question. Statement 1. The value of vote of MLAs in the electoral college is not the same for different states. Of course, we know that the value of vote of MLAs cannot be the same. Cannot be the same because the value of vote of an MLA depends upon the population of that particular state. It depends upon the population of that particular state, and no two state has the same population, and it also depends upon another variable, that is the number of elected MLAs from that particular state. So the variables include population and the elected MLAs, and hence no two state MLA will have the same value. That is very much true. And this is also because of the fact the constitution provides for what? Proportional representation. They don't want to give equal values to votes of all the MLAs, and the value has to vary depending upon the population of that particular state. A state which is having higher population, the value of vote of the MLAs may be higher. A state which is having lesser population, the value of vote of MLAs of those states may be lesser. So this statement is very much true. This is right. Second, anyone who is to be elected as the president needs to secure an electoral quota which is more than 50% of the total value of the valid votes polled. This is also very much true, because the election of the president in India is not based on the principle of first past the post system, but rather it is based on the principle of what? It is based on the principle of electoral quota and proportional representation. So anyone who is to be declared elected, they need to get more than 50% of the value of the votes that is polled. And that's why in the election, we also use what is called as the single transferable voting system. So this is very much true. Statement 3. A legislature voting in the election contrary to the party direction is liable to disqualified on the grounds of defection. So this is a very, very interesting thing. In fact, most of you might be aware that what is the principle based on which the presidential election happens in our country. The principle based on which the presidential election happens in our country is by proportional representation by means of single transferable vote, and the voting is by secret ballot. So what do you understand by the word secret ballot? Secret ballot means no one will know as to whom one has exercised his or her voting. So that means even if the members of the parliament or the members of the state legislature, if they vote contrary to their party direction, the party leadership will not come to know as to whom they have voted. And they are also not liable to be disqualified on the grounds of defection. The Election Commission of India in the RTA reply has very categorically said that if any member who is part of the electoral college, if they vote contrary to the party direction, which no one will come to know in the first place, otherwise also they are not liable to be disqualified on the grounds of defection. So this is also true. So which of the statements given above are incorrect? Statement 1 is correct, statement 2 is also correct, statement 3 is also correct. So the right answer would be option D, that is none of the above. Let us proceed to the next question. Question number 5. First let us read the question. Which of the following is the objective of giving constitutional status to panchayats and municipalities under the 73rd and the 74th Constitutional Amendment Act? Why this particular question is relevant? Because recently 30 years has been completed after giving constitutional status to panchayat and municipalities. We all know that the 73rd and the 74th Constitutional Amendment Act was brought in the year 1992. So despite 30 years, there is also criticism that the local bodies have not lived up to their expectation, but they also achieved to some extent and they also realized the objectives of giving them the constitutional status. So before I go with the statements in the question, so what could be the possible thing that you have to revise with regard to this particular topic? So what becomes relevant is the Schedule 11 and Schedule 12. So you should have an idea of these things. Gram Sabha. What is Gram Sabha? You should have an understanding. The provisions for reservation under the 73rd and 74th Constitutional Amendment Act. The institutions like the State Finance Commission, the State Election Commission, you should have an idea. What are the mandatory provisions and what are the voluntary provisions under the law? So these are all the probable areas from where the question can come. But now let us try to come to the question and let us try to solve the question. The question is asking what is the objective behind giving the constitutional status? But before that, what is the need to give the constitutional status? Is it not that the panchayat and municipalities were in existence before the commencement of the constitution? They were very much in existence. But earlier they were under the control of the state because local government is an item in the state list. And because it was an item in the state list, there is no uniformity with regard to their structure in the states. Different states have different structures. Not only there is no uniformity, there was also no regularity. So the basic problem is no uniformity and regularity. So the structure was not uniform and the bodies were not established regularly, the regular elections were not happening. That is one of the reasons as to why then the government of India decided they want to amend this constitution and they wanted to give a constitutional status. One is that they wanted to give uniformity in structure and regularity, but then the most important objective is to ensure people's participation in the governance. They wanted people at the lowest level to directly participate in the governance activities. Say for example, Gram Sabha is there. Gram Sabha is a body, they can decide a number of things. So that is the reason that they wanted people to more and more participate in meeting their needs themselves at the local level. So participation is very much an objective and to ensure accountability. So what happens at the local level is they elect their own representatives, and if the representatives are not taking care of the needs of the people, the local level, at the village level, be it electricity, road and all those things, they can go and ask their elected representatives, the village panchayat leader or the pradhan, whoever it is. So thereby they can also ensure more accountability in the system of governance. So these two are the basic objectives as to why the panchayat and municipalities were given a constitutional status. The idea is never to give direct democracy. In fact, the political system of India, it never goes with direct democracy because it's very clear that India is an indirect democracy. Although people participate at the local level, but it is not to give direct democracy. To implement universal adult franchise, we don't have to give constitutional status to panchayat and municipalities because the universal adult franchise has already been part of our constitution and it is already in existence where people elect the MPs and MLAs through the process of universal adult franchise. So this is also not the objective behind this. So choose the correct options from the codes given below. So the right answer would be both options 2 and 3. So choose the correct options from the codes given below. So the answer is to ensure accountability and people's participation in the governance. So the answer is option 2 and 3 only. So here it is option 2 and 3 only. So the right answer is option C. Okay. So this is how we'll have to prepare. You will not only prepare as to what is being there in the news, you will have to holistically cover all those things which will help you to understand and also to answer the questions. Let us move to the next question. Have a look into the next question. Consider the following statements regarding the Election Commission of India. So again, what is the context? What is the relevance of this particular question? Why it is important for the examination? If you see how it is relevant for the examination, you will understand recently there was a judgment which is given by the Supreme Court, a constitutional bench of the Supreme Court, which heard a matter related to appointment of the Chief Election Commissioner and the other election commissioners, which right now under Article 324 of the Constitution is done by the President of India. But a public interest litigation was filed. They said in the petition to the Supreme Court, please look into Article 324 of the Constitution. Article 324 of the Constitution says that the appointment of the Chief Election Commissioner and the other election commissioner shall be made by the President subject to any law made by the Parliament. That means the petition was stressing upon that the original intention of the Constituent Assembly is never to give this power to the executives, that is the President of India, but to confer this power upon the Parliament, and till the time the Parliament makes a law, the President can exercise this power. Why? Because Election Commission of India is the backbone of Indian democracy. The Election Commission of India has to be independent, and only if it is independent they can ensure a free and fair election, and without free and fair election you cannot have a democracy. And how does that independence come? That independence comes only if you appoint impartial members as the Chief Election Commissioner and the other election commissioner. And that's why it should not be left in the hands of executive, because the President is just going to act based on the aid and advice of the Council of Ministers. And this is what is the petition has exactly brought in. So after hearing all the petitions, the Supreme Court has also decided that henceforth the President will make the appointment, but the President will not act on the aid and advice of the Council of Ministers, which earlier has happened basically on the recommendation of the Prime Minister, but on the recommendation of a committee. And the committee will be headed by the Prime Minister. It will also have the leader of opposition in the Lok Sabha, and in case if there is no leader of opposition in the Lok Sabha, the leader of the single largest party in the Lok Sabha, and then the Chief Justice of India. So these three people will recommend to the President, and only those people will be appointed as the Chief Election Commissioner and the other election commissioners. But however, the Supreme Court has made it very clear that this judgment that is given by the Supreme Court, that the committee will henceforth recommend the President, can be overruled, or it can be altered by a law that is made by the parliament, because under Article 324 of the Constitution, ultimately it has to be done based on the law that is made by the parliament. So till the time the parliament comes out with any law, this committee system is going to prevail as per the decision of the Supreme Court. So in this context, this particular topic and this particular question become very relevant for the examination. So with this information, let us try to solve the question. Statement 1. The commission shall consist of the Chief Election Commissioner and such other election commissioner as the president may decide from time to time. Very, very important. The Constitution does not fix the membership of the election commission. It only says that it shall consist of the Chief Election Commissioner and such other election commissioners as the president may decide from time to time. So this is very much true. 2. The expenditure of the election commission is charged on the Consolidated Fund of India. It is not charged on the Consolidated Fund of India. It is rather made from the Consolidated Fund of India. In fact, this is one of the reform that the Election Commission of India is already asking, that its expenditure should be charged from the Consolidated Fund of India. So what difference does it make? Any expenditure that is charged on the Consolidated Fund of India, it can give better independence to the body, because any expenditure that is charged on the Consolidated Fund, it is not subject to vote. Not subject to vote in the parliament during the vote on demand for grant stage. It is not subject to vote. That means even the parliament cannot alter the expenditure that is likely to happen or incurred by the Election Commission of India. But the expenditure which is made, all those expenditure which is not charged is to be made from the Consolidated Fund, and the expenditure which is to be made can be altered, because the parliament has the right to vote. To be very specific, the Lok Sabha has the power to vote during the vote on demand for grant stage. So what is the second statement? The expenditure of the Election Commission is charged on the Consolidated Fund. As of now, it is not. In fact, this is the recommendation that they seek. Statement number 3. The Chief Election Commissioner and the other election commissioners shall be removed on the same manner as that of the judge of the Supreme Court. In fact, if you see, this protection under the Constitution is given only to the Chief Election Commissioner. The Chief Election Commissioner may be removed on the same manner as that of a judge of a Supreme Court, which means they can be removed only by a motion that is addressed in both the houses of the parliament by special majority and subsequently accepted by the president in the same session itself. But however, the same level of protection is not given to the election commissioners. So right now the Constitution says the election commissioners shall be removed by the president, but on the recommendation of the Chief Election Commissioner. So without the recommendation of Chief Election Commissioner, it cannot happen. In fact, this is also a demand that the Election Commission is already asking, that it should give equal level of protection to both the Chief Election Commissioner and the other election commissioners as well. So this question is very, very important topic. Such questions can always be asked in the examination. In fact, there is a lot of criticism to this judgment also, that it is some form of judicial overreach or judicial legislation or adventurism. But the Supreme Court said that in the interest of democracy, that they have to provide this particular judgment. So this particular statement is also wrong. So which of the statements given above are correct? So the right statement or the right answer is option B, that is 1 only. Okay. So this is with regard to this particular question. Let us move to the next important topic and next important theme, and let us see what is the next question. A very simple question, but why it has been asked or why it is relevant for this year's examination? Because of what has happened in the recent past. The question is, the ninth schedule was inserted into the Constitution by which Constitutional Amendment Act? The ninth schedule was in fact inserted into the Constitution by the first Constitutional Amendment Act. Everybody might knew that, a very simple question, but sometimes UPSC also asks such simple questions as well. And it is also very relevant for this year. It is because of the fact recently the Jharkhand government has passed a bill to increase the reservation in their government jobs up to 77%. And in order to provide immunity against judicial review, the Jharkhand government, the Jharkhand legislature has already passed a resolution requesting the parliament to place this bill or this act into the 9th schedule of the constitution. So, because once you place the law inside the 9th schedule, it will have complete immunity from being judicially reviewed. And then even if the reservation is over and above the principle of 50%, still it cannot be struck down by the courts, because the 77% reservation has a technical issue, because the Supreme Court in the Indira Sahni case in the year 1992 said that the reservation cannot be over and above the principle of 50%. So, they have brought in the 50% rule. So, in order to avoid any form of judicial review, any form of judicial scrutiny that may strike down this particular act, which is now providing 77% reservation, they want this to be placed inside the 9th schedule of the constitution, and in this context it was in the newspaper. So, you should be aware of the first Constitutional Amendment Act, and what is the source behind this 9th schedule of the constitution? It was Article 31B, because Article 31B provides for the 9th schedule, and 9th schedule saves all those laws which is placed in the 9th schedule from judicial review. But however, today the position of 9th schedule is not the same, and in this context we should also be aware of a case which is called as the IR Coelho case. The IR Coelho case in the year 2007 has said that any law that is placed even in the 9th schedule, which may be violative of Article 14, 19 and Article 21, still they may be judicially reviewed and they can be declared to be void. So, today please understand, the law that is placed inside the 9th schedule is not completely immune from judicial review, and they can be judicially reviewed if they are violative of Article 14, 19 and Article 21, because these fundamental rights are considered to be part of the basic structure, the most important provisions in the constitution. But however, you'll have to remember one important thing, that it is not that the Supreme Court will have the power to review all the laws which is placed inside the 9th schedule, which I think approximately today they have around 284 laws which is placed inside the 9th schedule. Not every law that is placed inside the 9th schedule can be judicially reviewed even after the IR Coelho case, but only those laws which may be violative of Article 14, 19 and Article 21, but placed after, on or after 24th April 1973. So, any law that is placed on or after 24th April 1973 into the 9th schedule can be judicially reviewed on the grounds of violation of Article 14, 19 and Article 21. So, this is exactly the judgment that is given by the IR Coelho case. So, you should remember all these things, including the Indira Sahni case, the judgment that has been given in the Indira Sahni case. So, the 9th schedule was inserted into the constitution by which Constitutional Amendment Act? The right answer is by the first Constitutional Amendment Act. So, this is how UPSC may connect to what happens in the current with that of the static part. So, you should be aware of the current developments, but with regard to the prelims, you should focus more on the static portions of those things which is around that current development, which will help you to answer the questions. Let's move to the next question. Have a look into the next question. Now, this question is also very important for the examination. Which of the following disputes can fall under the original jurisdiction of the Supreme Court? What is the relevance of this particular question? Recently, there was a dispute between the state of Maharashtra and the state of Karnataka over certain border districts. The state of Maharashtra is claiming that in certain districts, there is a majority Marathi speaking community, and hence those communities should be part of Maharashtra, which is not acceptable to the government of Karnataka. And hence, because there is a dispute between two states, which is a federal dispute, such disputes can be entertained only by the Supreme Court of India under Article 131 of the Constitution. So, in this context, Article 131 is very, very important. What Article 131 is saying? Any federal dispute, it falls under the original jurisdiction of the Supreme Court, which means the matter can be taken up only by the Supreme Court. Original jurisdiction of the Supreme Court. So, what kind of disputes may fall under the original jurisdiction? Any dispute between center versus state, any dispute between state versus state, any dispute between center and states on one side versus the states. So, probably these three combinations, any dispute, it may fall only under the original jurisdiction of the Supreme Court. But the question is, what about the interstate river water disputes? Any interstate river water disputes can also be seen as a federal dispute. So, interstate river water disputes, will they fall under the original jurisdiction of the Supreme Court? They will not. For which you will have to understand Article 262 of the Constitution. So, what Article 262 of the Constitution is saying? Article 262 of the Constitution is specifically mentioning that any interstate river water dispute shall be entertained only by such an authority as may be determined by an Act of Parliament. Accordingly, the Parliament has passed the Interstate River Water Disputes Act, and the Interstate River Water Dispute Act provides for ad hoc tribunal right now. And these tribunals will take up these matters. So, interstate river water disputes does not fall under their jurisdiction. Then the next thing is interstate border disputes. So, interstate border disputes is very much true that will fall under the original jurisdiction. Cases related to violation of fundamental rights. Now, cases related to violation of fundamental rights, although may directly go to the Supreme Court, but they will not go under the original jurisdiction. They fall under the writ jurisdiction of the Supreme Court under Article 32. So, in this context, all these informations are very relevant. Apart from that, you may also be aware of Article 263, which allows the President to establish an interstate council, which is basically to work on any disputes between the center and the states. But such a body has been established in 1990, which is very dysfunctional in our country right now. And in addition to that, what is another way if you want to resolve this border dispute? As Article 3 is there, where the Parliament is empowered to redraw the boundaries under Article 3, and thereby they can change the boundaries. So, this is also another thing. So, with this information, if you have to answer this particular question, choose the correct options from the quotes given below. So, interstate river water dispute, of course, it does not fall under the original jurisdiction. Interstate border disputes, yes, of course, yes. And cases related to violation of fundamental rights, it is not there. So, which of the options given in the code is correct? It is only option C, that is interstate border disputes. Let us move to the next question. The The next question is consider the following statements with regard to motion of thanks. Very important topic. In February 2022, a motion of thanks was passed in the Lok Sabha. In fact, it happens every year. So in this context, we will also try to understand the things that is related to the motion of thanks. So to understand this motion of thanks, probably we'll have to understand the provision of Article 87 and Article 176 of the Constitution, where both the President and the Governor respectively are empowered to make a special address. In the houses of the Parliament, usually a joint session will be called upon, and in the joint session a special address is made by the President under Article 87 and by the Governor of the state under Article 176. So when they are likely to make this special address? During the first session after the general elections. So whenever there is a first session after the general election, they can make this special address. That is one instance where they can do it. They can also do it the first session every year, which is of course the budget session. First session every year. So then also this special address can be made by the President. So what is the significance? In fact, we say that this is the address by the President, but the President does not make this address. Of course, he makes his address, but he does not prepare the speech. The speech is prepared by the government. During the first session of every year, the government will probably come out with a report card as to what they have achieved in the previous year, and they want the President to deliver that in the houses of the Parliament. And during the first session after the general election is over, the government comes and it says that what is their agenda for the next 5 years, what is that they are willing to achieve, and what kind of support they look forward from the opposition parties. So this is what is actually been presented in this special address, which happens at the respective time. But however, once the special address is completed by the President, in order to see as to whether there is a popular support in the House with regard to the address that is made by the President, because his address is made by whom? It is made by the President on behalf of the government. And under the parliamentary democracy, any agenda of the government or whatever the government proposes, there should be a popular support for that in the houses. So once the President delivers the address, what happens? A motion of thanks is introduced. A motion of thanks to thank the President for the address that he has made in the houses of the Parliament. In fact, this motion of thanks is separately introduced in both the houses of the Parliament, in the Lok Sabha as well as in the Rajya Sabha. It is introduced by someone from the government. But what happens to this motion once it is introduced in the Lok Sabha is very significant. Because once the motion of thanks is introduced, it will be discussed, the proposals that was discussed by the President will be discussed, and then finally it will be put to vote. And this motion of thanks has to be passed with simple majority. And we already seen as to what is a simple majority. And if the motion of thanks is not passed with simple majority in the Lok Sabha, let us assume, then it is automatically seen as what is called as the vote of no confidence. If it is passed, it is all right. But if it is not passed, it is seen as vote of no confidence. But if the motion of thanks is not passed in the Rajya Sabha, if it is not passed in the Rajya Sabha, it has no significance for the government. Because under the Constitution of India, the government or the Council of Ministers is only collectively responsible to the Lok Sabha and not to the Rajya Sabha. So these are all the information that you should know with regard to the motion of thanks. So with this information, let us just try to solve this particular question. The motion is passed during the first session of the Parliament every year after the presidential address. So this is true not only during the first session but also during the first session after the general election. Then the second statement, the defeat of the motion in the Lok Sabha shall be considered as a vote of no confidence. That is also very much true. That means it is a clear indication that the government is not having the majority. So which of these statements given above is are incorrect? So when you say incorrect, it is neither one nor two, because both the statements are correct as per the question. Come, let us go to the last question for today. Consider the following statements with regard to the private member bill. Very, very important question again, in my opinion, for you to understand as to what is a private member bill. Now, why this particular question is very relevant? Because in the recent context, recently a private member has introduced a bill where he wanted to empower the Election Commission of India to regulate the internal affairs of the political parties. And also this bill was introduced in the backdrop of the PIL that we have just discussed, which was pending in the Supreme Court with regard to having a committee that would recommend the President of India to appoint the Chief Election Commissioner and the other election commissioners. So this bill has also had a provision that a committee headed by the Prime Minister would recommend the President to appoint the Chief Election Commissioner and the other election commissioners. So all these provisions were part of the bill, but this bill was introduced as a private member bill. So what is this private member bill? That is what we'll have to understand. So before I get into the question, so technically speaking, you can divide the bill depending upon two things. Depending upon who is introducing the bill, it can be called as a private member bill, or it is called as a government bill. And depending upon the subject matter, most importantly, depending upon the subject matter, the bill can be introduced or divided into different types. Especially it can be called as ordinary bill, financial bill, and then money bill, which is also a part of a financial bill, a type of financial bill, and constitutional amendment bill. Depending upon the subject matter as to what actually the bill deals with. So this is how you can classify the bills. So what is a private member bill? What is a government bill? Any bill that is introduced by a minister in the house is a government bill. So these two are mutually exclusive. So what is a private member bill? A bill which is introduced by a private member who is not a minister. So someone who is not a minister, it doesn't matter whether he is from the ruling party or from the opposition party. If he is not a minister, then he is a private member. And if he introduces a bill, that's a private member bill. So please understand, under the Constitution of India, most of the bills can be introduced. What is a bill? We know that it is a legislative proposal. Most of the bills can be introduced either by a minister or by a private member. But however, indirectly, the Constitution prevents a private member from introducing certain types of bills. So for example, what are the bills a private member can also introduce, and what are the bills a private member cannot introduce? Under the Constitution of India, you know that for introducing certain types of bills, there is a need for the prior recommendation of the President. That means you'll have to seek the permission of the President to introduce the bill, which is not the case in all the types of bills. But for certain bills, you need the prior recommendation of the President. So for example, any bill under Article 3 of the Constitution, which is aimed at reorganizing the states, it requires a prior recommendation. When you talk of prior recommendation, we know that the President of India acts on the aid and advice of the Council of Ministers. That's the crux of Article 74. So only when the ministers are going to advise, then only is going to give the recommendation for introducing such a bill, which may not be possible in case of a private member bill, because a private member does not speak for the government. The minister speaks for the government. So under Article 3, a private member cannot introduce. So can he introduce under Article 3? Not possible. Second thing, a money bill requires a prior recommendation. So a money bill can also not be introduced by a private member. A private member can also not introduce financial bill type 1, which also requires the prior recommendation of the president. So these three types of bills cannot be introduced by a private member. What type of bills can be introduced by a private member? A private member can introduce an ordinary bill. This can be done by a private member. A private member can introduce a constitutional amendment bill. This can be done. The constitution does not prohibit him. A private member can also introduce a financial bill type 2. Type 2 can be introduced by him. So this is also possible for a private member. So what he can do basically ordinary bill can be introduced, financial bill type 2 can be introduced, constitutional amendment bill can be introduced by a private member. What cannot be introduced by a private member, although the constitution does not explicitly say that, is a bill trying to reorganize the states, money bills can be introduced, and the financial bill type 1. So with this information, try to come to this particular question. Consider the following statements with regard to the private member bill. It's a bill which is introduced by a member of parliament from the opposition party, not necessarily. I have already said a private member is not necessarily from the opposition party. A private member is someone who is not a minister. 2. A constitutional amendment bill can be introduced by a private member, that it can be done. So we already seen what are the bills which can be introduced by the private member. So which of the statements given above are incorrect? So the incorrect statement is option A, 1 only. Okay. So today we have discussed certain important current topics, but how those current topics are relevant to the conventional areas in the constitution. So today we have discussed 10 questions. So in the coming episodes, we'll also try to discuss more questions. So the idea is to cover 100 most probable topics which may be very relevant for the preliminary examination 2023. So to watch more of these questions and discussions, you may also subscribe to the StudyIQ English channel. Thank you very much. God bless.